Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, it has been a tumultuous couple of weeks before the United States Supreme Court. We've gotten really terrible news. We've gotten really good news. Been doing a lot of geeking out, not only on the orders list, but on pending petitions, and came across one that I find to be rather fascinating and very well briefed. This is a challenge to the constitutionality of the federal restrictions on short barrel rifles. Is there actually a historical tradition that would justify this regulatory scheme? The answer obviously is not. But we're going to share with you today a petition, a charge that is being led by the NRA that we think's got some teeth. Now, I don't know if the Supreme Court's going to have any interest, but we certainly have some interest, and therefore we want to share it with you today. So today, let's spend a few minutes and let's talk about, here comes the challenge to the government's restrictions on SBRs. Okay, America, what we are talking about today is a challenge to the federal regulations that require SBRs to be part of the National Firearm Act. Of course, when we're talking about SBRs, we're talking about short barrel rifles, firearms with a rifle bore designed to be fired from the shoulder that has a barrel less than 16 inches. The specific case we're talking about today is the matter of Rush versus United States of America. The NRA is actually leading the charge on this. We're going to go through their memorandum here in a moment. And of course, that means we got a link for them down in the description box in case any of you want to show them some love. Now, what I really like about this petition is the focus point is not really on the government's regulation of SBRs. The focal point instead is on how all of the lower courts are completely all over the board about what even constitutes an arm. Okay, and that is a big problem. And with the Supreme Court just essentially turning a blind eye to this in common use for self-defense or more appropriate for military use, what we have allowed these lower courts to do is to come up with a complete tapestry of what is or is not protected arms under the Second Amendment. As the petitioners point out here, lower courts are unsure how to adjudicate challenges to restrictions on specific categories of arms and have thus adopted a variety of different, often conflicting approaches, many of which are inconsistent with this court's precedents. This confusion is most pronounced in the Seventh Circuit, which has issued opinions inconsistent not only with this court's precedents and decisions in other circuits, but also with its own precedents. And of course, this case comes out of the Seventh Circuit, which next to the Ninth Circuit, no circuit court plays more gamesmanship with your Second Amendment rights. Take, for example, what happened at the lower court level. In this case, for instance, despite having previously rejected this court's common use test as a circular and not very helpful, slippery concept that would have anomalous consequences, the Seventh Circuit required proof that short barrel rifles are commonly used for lawful purposes, but then dismissed evidence showing how many are possessed by law-abiding citizens. Yeah, you see, many of these courts that are hell-bent on civilian disarmament, they don't like the common use test because the common use test is what? A simple numerical value. So they have gone around and bastardized this test in more ways than is humanly imaginable, including the Seventh Circuit, which has decided to do it this way. The Seventh Circuit has manufactured its own test, which seemingly cannot be satisfied. In this case, the court paradoxically dismissed the short barrel rifle's popularity and proliferation as having little jurisprudential value, while simultaneously concluding that Rush failed to prove that they are commonly used for lawful purposes. And ultimately, the biggest reason that the United States Supreme Court should accept this petition, not saying that they will, we know that for sure, but the biggest reason is because until we have uniformity amongst the lower courts as to what's even considered an arm, well, we are never going to have uniformity in the application of our Second Amendment rights. And so the petitioners here very wisely point out the courts of appeals are split over whether all firearms are arms. And there is a laundry list of cases that have found that arms, clearly arms under any common sense definition, magically are not arms when we're trying to consider them under Second Amendment protections. Take, for example, United States versus Price out of the Fourth Circuit. Bianchi versus Brown, now known as Snope v. Brown, also out of the Fourth Circuit. Beavis versus City of Naperville, out of the Seventh Circuit. Rocky Mountain Gun Owners v. Polis, out of the 10th Circuit. And this unwillingness or this creativity to start excluding arms from Second Amendment protection is really about one of the only ways that these courts hell-bent on civilian disarmament can continue to uphold these bans. Because if it really was the common use test, as is announced clearly in case law, these bans could not stand because, well, there would be no historical analog. And so, as the petitioners very wisely point out, Bruen repeatedly stated that the only way government can justify an arms-bearing regulation is with historical tradition. But by excluding even some of the most popular firearms in the country from the scope of the plain text, lower courts are fundamentally altering this court's test for Second Amendment cases. And that is truly the biggest issue, because these courts are coming up with 101 different ways to work around the rule of law, which is the common use test. And the common use test really is a corner-cutting method for courts, because when it comes to firearm bans, we don't need to do a historical analysis. It's been done for us already. If the firearms are in common use for any lawful purpose, including self-defense, as one of them, they may not be banned. And again, the historical analysis has been done for us because the only arms which can be categorically banned are arms that we believe to be dangerous and unusual. But of course, what some courts are doing is they are mixing up whether or not that's a component of the first part. That is, does the plain text of the Second Amendment cover the activity, or is it part of the second part of the inquiry, which is the historical analysis? The courts of appeals are confused over whether common use should be considered in the plain text or historical inquiry. And not only can they not figure out what part of the test is this component fit into, but they really can't come to any consensus on what constitutes in common use. As the petitioners point out, some courts of appeals are divided over what constitutes common use, while other courts have rejected this court's common use test altogether. And there are many other ways in which they try to preclude items from being covered under the plain text of the Second Amendment. As petitioners point out, the courts of appeals are divided over whether the Second Amendment excludes arms that are most useful in military service. Because by deeming them most useful in military service, which is a judicial predetermination, or what we like to call a balancing test, they believe that they can then uphold these bans. Petitioners also point out that either there is confusion or what I believe is actually willful denial of clear case law when they point out the courts of appeals are confused about what makes an arm dangerous and unusual. Because that truly is the test, and really what it all comes down to is unusual, because I think we can all agree that arms, by their design, are dangerous, and certainly in the hands of idiots, they are incredibly dangerous. The question becomes, how unusual are they? And there is no doubt that short barrel rifles are in circulation in the United States by lawful responsible gun owners by the hundreds and hundreds of thousands. And the petitioners raise a really interesting issue, which is that, the one case that you all use to justify any type of NFA regulation is United States v. Miller. But is it possible that an item that was previously banned could become so in common use that that ban would no longer actually apply? Well, it's interesting food for thought, because in taking a look at the history of Miller, the petitioners pointed out, whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are indisputably in common use for self-defense today. Thus, even if these colonial laws prohibited the carrying of handguns because they were considered dangerous and unusual weapons in the 1690s, they provide no justification for laws restricting the public carry of weapons today that are unquestionably in common use today. But the biggest reason why this petition needs to be accepted, or any one of these petitions for that matter need to be accepted, is that despite the fact in the summer of 2022, it appeared that the Supreme Court was divorcing balancing tests from any type of Second Amendment constitutional inquiry, none of the lower courts have in fact gotten that memo. Yet we still see court after court after court making their own independent determination as to what they believe is appropriate for self-defense, and therefore what they believe American citizens should be entitled to. As the petitioners point out, it is not for the government to decide whether a characteristic of a firearm adds sufficient functionality to the firearm for lawful use. Our Constitution allows the American people, not the government, to decide which weapons are useful for self-defense. And of course, since the test is in common use for any lawful purpose, And of course, since we require American citizens to go through extensive background checks in order to obtain an NFA item, I think it's pretty safe to say that they are possessed for lawful purposes, as the petitioner points out. Moreover, since the NFA requires short-barrel rifle owners to undergo extensive background checks, the 500,000 registered rifles are unquestionably typically possessed by law-abiding citizens for lawful purposes. So listen, there is a lot of important things going on here with this petition for certiorari, but the biggest one goes well beyond just the regulation of short barrel rifles. No, the biggest one goes to trying to bring some level of consistency, to trying to bring some level of common sense, to trying to bring some attachment to reality to these lower courts who are consistently just bastardizing the clear rule of laws, making their own rule of laws, coming up with their own balancing test, all designed with one intent and purpose, which of course is to keep you, the lawful and responsible gun-owning American, disarmed. And until the Supreme Court shows that it actually has a spine, that its rules of law actually have meaning, that they are willing to enforce their rules of law, that they are more than willing to provide guidance and direction to the lower courts, which is in fact their entire purpose, then the number of states that are going to be willing to double and triple down on their civilian disarmament measures through outright bans, and the number of courts that are going to be willing to bastardize any rule of law to uphold them, well, it's just going to grow in frequency now, isn't it? Listen, this is a really, really important petition for multiple reasons, so let's everyone keep our eye on it. The case, once again, is Rush versus United States of America. We're going to link up the petition down below so that you can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that's down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.